Thank you everyone for coming here today to join us for our IPPNW Seed Speaker Series. Dr. John Burroughs will be our speaker today, and we are so thrilled to have him. Dr. John Burroughs is a senior analyst for Lawyers Committee on Nuclear Policy in New York City, and from February 1999 to September 2020, he was the executive director. He has represented LCNP in the Nuclear Non-Proliferation Treaty review proceedings and in negotiations on the treaty to prohibit nuclear weapons. He was a member of the legal team for the Marshall Islands in its nuclear disarmament cases in the International Court of Justice. He has also published articles and op-eds in journals and newspapers, including Arms Control Today, Bulletin of the Atomic Scientists, the World Policy Journal, Newsweek, and Newsday. He has taught international law as an adjunct professor at Rutgers Law School. He also has a JD and PhD from the University of California at Berkeley and a BA from Harvard University. So thank you, John, for coming and joining us today. We are so excited to hear you speak.
Well, thank you for asking me. And I'm glad to see some people I know on this Zoom. So let me start with aggression. The most members of the Security Council were prepared to condemn the Russian invasion of Ukraine as aggression. But, you know, it was vetoed by Russia. Then the UN General Assembly on 2 occasions condemned the invasion as aggression in violation of the UN Charter. The International Court of Justice also decided in an interim order that Russia was ordered to cease military operations because it had wrongly invaded another country using a false pretext of preventing genocide. And in fact, if there are lawyers among you or even non-lawyers, there's always an issue of how you get in front of the ICJ. Well, in this case, there was clear-cut jurisdiction under the Genocide Convention just because of the way that treaty is written. And the fact that one of the rationales for the invasion used by Russia and Putin was prevention of genocide gave Ukraine the ability to go before the International Court of Justice. So there has been sort of a widespread understanding that the Russian invasion is aggression in violation of the UN Charter and international law. Then the question can be asked, well, what difference does that make? How do you bring Russia into compliance? How do you, quote, enforce it? But that's not my point right now. My point is that there is a wide understanding of the illegality of the invasion as such. What about the Russian threats to use nuclear weapons in connection with the invasion of Ukraine? There, the condemnation has been lacking. There was a paragraph in the first General Assembly resolution that referred to the nuclear threat, but essentially it really has not been a center of attention in terms of international norms, international law. Well, why is that? I think it's partly or mostly because the United States and other powerful states like Russia rely on nuclear weapons. So they're not in a good position to press for a condemnation of Russian nuclear threats as illegal. But there is a very, very, very strong case that they are illegal. And that's what I want to talk about tonight. And it's partly because I just think at a minimum, it can be one component of advocacy about the invasion and more generally about various countries' reliance on nuclear weapons. So let me remind you of what the Russian government said, or more specifically, Putin. On the day of the invasion, he said, "For those who may be tempted to interfere in these developments from the outside, they must know that Russia will respond immediately, and the consequences will be such as you have never seen in your entire history." That wasn't the only time. On April 27th, Putin said, "If anyone sets out to intervene in the current events from the outside and creates unacceptable threats for us that are strategic in nature, they should know that our response will be lightning fast. We have all the tools for this that no one else can boast of having." This is an apparent reference to the innovative nuclear delivery systems that Russia is pursuing, like the, what is it, the nuclear powered underwater drone. So Putin went on, "We won't boast about it. We'll use them if needed." And I want everyone to know that. Now, other Russian officials have given less inflammatory statements, though that is hardly reassuring given Putin's status as president. In a March 26 interview, Dmitry Medvedev, now deputy chairman of the Russian Security Council, former president, said that Russia is entitled to use nuclear weapons when attacked by nuclear weapons, when critical infrastructure for nuclear weapons is attacked. This could be a reference to, say, cyber attacks on Russian command and control. And I'm going to quote here, "when an act of aggression is committed against Russia and its allies, which jeopardize the existence of the country itself, even without the use of nuclear weapons," that is, with the use of conventional weapons. So unlike Putin's statements, Medvedev's explanation does not indicate that Russia would use nuclear weapons in Ukraine to avert a military loss, or that it would do so in response to a US NATO military intervention restricted to defending Ukraine or humanitarian corridors. Now, as a side point, let me say that Medvedev's statement basically reflects, insofar as we're able to understand it, Russian doctrine. And Russian doctrine, in its essentials, is very similar to the doctrine of the United States, which has been for decades that it will use nuclear weapons first, if necessary, to defend vital interests. And apparently, that is phrased in different ways over the years. It was phrased in a sort of a less belligerent way by the Obama administration, a more belligerent way by the Trump administration, and reportedly the Biden administration has a nuclear posture review not yet made public, which does not rule out first use, but probably doesn't have the sort of belligerent flavor of the Trump statement. But let me return to what we've been facing in recent years in terms of nuclear threats. I've noticed even among people, just one moment, even among arms control specialists, there's somewhat of a tendency to say, "Oh my God, Putin's threats are unprecedented. Well, in certain ways, perhaps, but let me remind you that just 5 years ago, in the summer and autumn of 2017, the US and North Korea exchanged incendiary threats of nuclear destruction. At the UN on September 19th, 2017, Trump said, "The US has great strength and patience, but if it is forced to defend itself or its allies, we will have no choice but to totally destroy North Korea. Rocket Man is on a suicide mission for himself and for his regime." North Korean Foreign Minister Ri Yong Ho responded in a couple of weeks, saying that North Korean nuclear forces are a war deterrent for putting an end to nuclear threat of the US and for preventing its military invasion, referred to our rocket's visit to the entire US mainland, and called Trump mentally deranged. This may have sort of been lost track of. In September of 2019, Pakistan referred to possible nuclear war in connection with the dispute with India over Kashmir. Prime Minister Khan at the UN said, "When a nuclear-armed country fights to the end, it will have consequences far beyond the borders. It will have consequences for the world." And he added, "That's not a threat, it's a fair worry." At the time, India had substantially increased the number of its troops in Kashmir and imposed a curfew. Of these episodes, Russia's threats are the most alarming because they occur in the context of a full-scale armed conflict arising out of Russia's invasion of Ukraine. Putin's 24 February statement, without question, is a legally cognizable threat, both credible and specific in form. In a concrete context, one of armed conflict, the message is, if you do not refrain from X, or if you do Y, we will resort to nuclear arms. It expresses a readiness to resort to nuclear force should addressee states, US and NATO, interfere in Russian military operations in Ukraine. So Putin's threat is illegal under the UN Charter, in Latin, jus ad bellum, the international law governing when it is permissible to use force. It is an element of the unlawful invasion, the use of force against the territorial integrity and independence of a state in violation of Article 2.4 of the UN Charter. The threat seeks to shield unlawful Russian conventional military operations by deterring NATO states from a direct military intervention to assist in Ukraine's lawful self-defense pursuant to Article 51 of the Charter. Such an intervention by NATO states would be lawful if requested by Ukraine. So this feature, the integration of threats to use nuclear weapons into an actual and aggressive attack, distinguishes the Russian invasion of Ukraine from other recent episodes involving threats of use of nuclear weapons. Importantly, threats to use nuclear weapons are also illegal under the law governing the conduct of warfare, now known as international humanitarian law, in Latin, jus in bello. So threats to use nuclear weapons are also illegal under international humanitarian law, at least when an armed conflict is actually taking place. That illegality applies regardless of whether the circumstance is one in which the threat is made by an aggressor state or a state acting in self-defense. IHL applies to both sides of a conflict. So Putin's threat is clearly illegal in that respect as well. It's a violation of international humanitarian law. Now, as for the references to use of nuclear weapons made in the US, North Korea episode, the Pakistan, India episode, they also appear illegal, though less clearly so. Under the law governing resort to force, any threat must not be aggressive, and if made in self-defense, must be necessary and proportional. Whether those threats are illegal under IHL could be debated because no armed conflict was taking place. Whether or not they're considered illegal, they are certainly dangerous, illegitimate, and unacceptable. So I have referred quickly to the applicable international law, and forgive me for this. I hope I don't put you to sleep, but I want to go over the international law in a bit more detail. So as far as the law governing resort to force, as I mentioned, Article 2.4 of the UN Charter provides that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations. If you look closely at the preamble to the TPNW, you will see that that obligation from the UN Charter is recited there. And by the way, the preamble to the TPNW should be studied closely. It's really a marvelous piece of work, and it, reflects work on sort of the normative critique of nuclear weapons that's been taking place over decades at the United Nations. So if a use of force would violate Article 2.4, a threat to engage in such force violates that article. As the International Court of Justice stated in its 1996 Nuclear Weapons Advisory Opinion, the notions of threat and use of force under Article 2, Paragraph 4 stand together in the sense that if the use of force itself in a given case is illegal, for whatever reason, the threat to use such force will likewise be illegal. It follows that under the modern jus ad bellum codified in the UN Charter, a threat to use nuclear weapons as part of an aggressive attack is illegal. As the ICJ also explained, and as I mentioned, a use or threat of force in self-defense must be necessary and proportional. So a defensive threat to use nuclear weapons that did not meet those criteria would also be illegal under jus ad bellum. What about the law governing the conduct of hostilities? International humanitarian law. Any threat to use nuclear weapons, whether aggressive or defensive, must also be of a use that would comply with international humanitarian law, at least when an armed conflict is taking place. So here's an important sentence from the ICJ opinion, sort of buried in the opinion, but unfortunately is highly relevant now. The ICJ, the International Court of Justice, said, if an envisaged use of weapons would not meet the requirements of humanitarian law, a threat to engage in such use would also be contrary to that law. So you can see that the illegality of a threat to use nuclear weapons under IHL depends upon the illegality of the use. That the use of nuclear weapons is contrary to IHL is powerfully communicated by the TPNW's prohibition of use, its recitation of relevant principles and rules of IHL in the preamble, and its clear and central aim of avoiding the catastrophic humanitarian consequences of such use. More generally, and let me sort of outline this area of the law, nuclear weapons cannot be used in compliance with the fundamental international humanitarian law principles of distinction, proportionality, and precaution. The basic incompatibility of use of nuclear arms with the principle of distinction between civilians and military targets is a central point of the ICJ's 1996 advisory opinion. Incompatibility with all three principles was affirmed by the Red Cross, Red Crescent in a 2011 resolution, which finds it difficult to envisage how any use of nuclear weapons could be compatible with international humanitarian law, IHL, and is reflected, as I said, in the 2017 Treaty on the Prohibition of Nuclear Weapons. Let me just add here that in the 1950s, I think it was the early 1950s, certainly right after Hiroshima and Nagasaki, the Red Cross spoke out against nuclear weapons and their use. It sort of went silent for a few decades. I don't know why. They had plenty of other things to work on, and may have thought it wasn't very fruitful to work on the problem of nuclear weapons. But they woke up in the 2000s, and by 2010, they were very active, and they played an active role in the negotiation. They served as the experts, essentially, for negotiation of the TPNW. And so incompatibility with the principles of IHL is also reflected, as I said, in the TPNW. There are other rules of particular relevance to nuclear weapons, those specifically regulating damage to the environment and reprisals. Protocol 1 to the Geneva Conventions, which is basically the key modern IHL treaty, prohibits the use of methods of warfare which are intended to or may be expected to cause widespread, long-term, and severe damage to the natural environment. It's like written for nuclear weapons. Then there is the problem of so-called reprisal. A response to an illegal attack may be justified as reprisal aimed at deterring further such attacks. It's one claim basis for the doctrine of retaliatory nuclear deterrence. However, any reprisal must meet basic requirements of necessity and proportionality, as I've already mentioned. But further, under Protocol 1, a reprisal must not be directed against civilian populations and targets. So, considering all of the above rules and taking into account as well the role in international law of elementary considerations of humanity and the dictates of the public conscience, a limited use of one or more nuclear weapons would violate IHL and constitute a war crime. It need hardly be said that a large-scale exchange of nuclear weapons would be a catastrophe beyond history, whose sheer madness, immorality, and illegality would be manifest. So why am I talking about the illegality of use of nuclear weapons under IHL? It's because if the use is illegal, then threats to use such weapons are also illegal, as the ICJ stated as a general principle. And this illegality of threats, nuclear threats under IHL, is reinforced by certain provisions of Protocol 1. It provides that acts or threats of violence, the primary purpose of which is to spread terror among the civilian population, are prohibited. It also prohibits threatening that there shall be no survivors. Also mentioned in the TPNW preamble is international human rights law. The illegality of threat as well as use of nuclear weapons under human rights law was recently stated by the UN Human Rights Committee, which is the treaty body for one of the three main covenants on human rights. That's the Covenant on Civil, Political, and Social, Civil and Political Rights. In a 2018 general comment, the committee found the threat or use of nuclear weapons, in particular nuclear weapons, the threat or use of weapons of mass destruction, in particular nuclear weapons, is incompatible with respect for the right to life and may amount to a crime under international law. So the nuclear armed states and their allies have not accepted the proposition that threats to use nuclear weapons, whether defensive or aggressive, are comprehensively illegal. Nonetheless, in my view, and the view of the International Association of Lawyers Against Nuclear Arms, that proposition is correct. It is well grounded in the above sources, and I note in particular the transcendence, the 1996 advisory opinion, of the articulation of the applicable law by the International Committee of the Red Cross, the TPNW, and the UN Human Rights Committee. The world needs to come to grips with the unacceptability and illegality of threats to use nuclear weapons. That has been demonstrated by Russian threats this year and by threats by other countries in recent years. It would seem obvious that threats to use nuclear weapons increase in a major way the risk that they will be actually used. So there are just dangers involved with nuclear threats. Beyond those dangers, this kind of blatant reliance on nuclear weapons severely undermines prospects, and I think I'm understating the matter, severely undermines prospects for progress on nuclear arms control and disarmament. I understand that the political declaration to be released by the first meeting of states parties to the TPNW will strongly condemn nuclear threats. Good. And to sort of support that and inform that, the International Association of Lawyers Against Nuclear Arms, IALANA, has just put a working paper in to UN Office for Disarmament Affairs, which is serving as the secretariat for the first meeting. And that should be available on their website and LCNP's website soon. And we also have a paper on our website, End the War, Stop the War Crimes, which goes into, in some depth, the issues I've been talking about. So, be good if there's a political declaration from the first meeting of states parties that includes a condemnation of threats, nuclear threats. It's certainly possible, and I'm sure, I know that some NGOs and governments will be advocating for this, that the NPT review conference to be held in August will address the question. It probably can't get into an outcome document, but I'm sure it will come up at least in statements of governments. We need to free the world of nuclear threats, nuclear terror, and to create a human rights-based peace. So that's the end of my talk. Look forward to a discussion.
Thank you so much, John. And I'll do a little round of applause.
Thank you.